Well, good morning, everybody, and welcome. It is 10 a.m. and another beautiful day in San Diego, California. Thank you for being here today. We are at the Greater San Diego Association of Realtors, and my name is Kevin Burke. There is my telephone number, and there is my email address. Certainly, email, one of the easier ways to get a hold of me. Hi, Sherry. Wow, welcome back. Good to see you. I have some credentials, I guess, that make me qualified to speak about the subject matter. I've been a broker for a very long time. I am a broker in multiple states and a certified instructor in several as well. And so I do currently continue 25 years later to teach attorneys real property law, continuing education at UCSD. And as you can see on the right-hand side, my whole career is all about risk management. So hopefully that's a good thing for us here today, because I've always said I'd rather practice risk management than damage control, right? We're going to be talking about stuff today that's going to appear to be legal. I am not a practicing attorney. I want to make that very clear. I have no interest at all. I think they work harder than we do, and I think we make more money than they do. So my trial work is limited to testifying as an expert witness. Standard of care is my specialty for real estate licensees, agents' duties of inspection and disclosure, and market conditions in San Diego County. So our conversation today is not intended to be a substitute for the advice of your broker, nor for that of your attorney. Please consult with them as appropriate. You're paying them to be there. You should be talking to them. They want to hear from you, okay? Talk today is intended to be interactive. Please ask questions or offer input by utilizing the Q&A button. I'd love to be able to go hot mic, but one of the problems with the Zoom program, as you might know, is that if even after somebody mutes themselves, it has a tendency of turning itself back on again. Blah, blah, blah. Okay, all right. I do look forward to hearing from you, please. And so it really helps me to understand what it is that you're seeing. I'm a practitioner like you, but if you ask questions, it'll help me to guide the direction of our conversation today. Okay, all right. So today, this is July the 11th. We're going to be talking about the TDS, the SPQ, the SPQA, and the Avid. And then this afternoon, we're going to hit disclosures, and we're going to talk about the difference between the statutory and the contractual disclosures. On Thursday, more of a practical side of things, we're going to talk about mastering your farm. I have quite a class. I'm going to redo it again anyway, as I always do. You know me, I redo these things every time before I speak. So I'm going to redo that one as well. And then in the afternoon on Thursday, I'm going to show you again how to create that winning listing presentation. I've never gotten a listing I didn't want. I have turned down listings that I didn't want, but hopefully that works for you as well. So anyway, that being said, today, thank you for joining us for our discussion of the TDS, the SPQ, the SPQA, and of course, the Avid. And so starting off, why are they required? And so in California, there is no buyer beware. A lot of people think that it is, but it absolutely is not. There is, however, caveat vendors. So caveat emptor would be buyer beware, but in California, it is seller beware. Okay, and so we'll talk about a couple of things, and we are going to launch into the forms. We're going to spend quite a bit of time on those. So why are they required of the seller? And we're requiring them from the seller because to assure that those with the most knowledge about the property share that information with the buyer. And we'll talk about a couple of court cases that kind of solidified that. Why are they required of the agent? They're required to assure that the real estate professional does their due diligence in the real estate transaction. And so nowhere but in a court of law have I seen professional associated with a real estate licensee as when they're putting that PowerPoint up there for the jury to see. Usually plaintiff's counsel is trying to, using the fact that you are a professional, you have a license, and so you have qualifications to help people with their real estate transaction. So let's talk about the Easton case. And so I just wanted to hit on this one really quick. And we're going to talk about a couple of cases today. But let me see if I can get us over to it without too much fanfare. Here we go. The Easton case, of course, the granddaddy of all of them. This case was an appellate court decision back in 1984. I'm not going to dig deep into this because it's not a law class, but anyway, this was a case where the buyers sued the seller and the real estate company for not disclosing to them certain material facts about the property. And so in this case, it did not go well for the real estate agents, but I think it went well for the public in general. And I think it went well for us for later as well. Again, I'm not going to go through the entire case, but essentially what happened, take my word for it, it was a slippery soils case where there was a soil subsidence that occurred at the property. The agents were aware of it. The seller was aware of it, and at that time, everybody said "buyer beware," that kind of thing. And so again, not a law class here today, but this was the one that started the whole thing, and this one produced some other results for us as well in our civil code items. Okay, so that being said, then I'm going to fly back over here to the PowerPoint real quick. So that's my Easton case, which is the predecessor to what we're going to be talking about today. But let's also talk about the Field case. And the Field case came out of Otay Mesa. That one's really close to home. That one occurred and more recently in 1998, and it was also an appellate court decision. It was released for publication. The entire case was not released, but part of it was, and the part that was released was the part that the partial publication. It had to do with the fact that the buyer purchased a home in a rural area of Chula Vista, Otay Mesa, and the buyer did not get access to their preliminary title report until after the transaction closed. Of course, at that point, they read the preliminary title report and discovered that the city of Otay Mesa had an easement against their property, that at any point they could dump the bilges, as we say in the Navy, open up the water tank on the adjoining property and not only flood this property, but also flood the residents as well. And so, of course, you can only imagine that the buyers did not like that fact. I guess I'd probably feel the same way. The case itself really wasn't a case about disclosure as much as it was about the statute of limitations and whether or not the 2-year limitations of 2079 barred an action against the real estate company. And so the case obviously went down at the local level, and then it went up to the appellate level. And of course, as you probably know, by the time you get to the appellate level, you've spent a lot of money on this. And in order to kick it up another rung, you're going to spend a lot more money. And so everybody just kind of decided to let it go at this point. But the issue was the dicta, as we say, that the judge had in their publication about the case. And so they were not very friendly with the real estate agent. And in fact, they were very damning for the real estate agent. And so it impacted our business of real estate in that it kind of threw things up in the air as to whether or not we had an obligation to know more than something that was necessarily required to get our real estate license. And so in this case, that was what came out of the opinion. And so I've actually got a highlighted version of this, and all of the things that I talk about here today, if they're of interest to you, all of the things that I talk about, I am more than happy to send these to you if you just send me an email and say, can you please forward that information, the material that you discussed today. So that's the Field case. So we started off with Easton. Easton was the case where the agents were later held to have an obligation to essentially do a reasonably competent, diligent visual inspection of the premises, and again the foreshadow of our Civil Code 2079. So let's talk about some let's talk about the real estate transfer disclosure statement. And again, stop me at any point if you have a question, please stop me. But we're going to talk about the TDS. And so it's the CAR form TDS, and it just went through another revision. So hopefully you're using the current form. Remember that if you're using the current form, you may have some protection from the user protection agreement. If you're using an older form, there is no such protection. And remember, one of the reasons why we update these forms is because we have to edit them based on legislation, based on litigation. And this was actually a legislative change because the TDS is a legislative form. Okay, it's a statutory form. And so it was, we had to update it. It took effect on July 1st. We actually didn't update it until June the 27th. And so, so if you are doing a transaction, you're in the middle of a transaction right now where everybody has already signed the TDS, whatever version it is, my advice would be to continue to use that version. You check with your broker as to whether or not you should use the new version of the TDS. But frankly, I like the TDS, and it's one of those forms that certainly gives me a lot of business. So the TDS law itself took effect in 1985, which was just before the Easton case, the appellate level of the Easton case. And it was an addition of disclosures upon transfer of real property that was put into Civil Code 1102. So again, California Civil Code 1102 addresses the seller's obligations to make disclosures about certain things about the property. And so it requires a seller disclose to the buyers any material facts. And I broke this down into its parts because I think you'll find that material for one person may not be material for someone else. So we are trained in our industry to disclose everything, right? To tell them everything. And in the immortal words of Pete Selecki, who is currently our general counsel for SDAR, he says, you just tell them everything. They can't sue you for what you tell them. So a material fact, again, what would be material to the person? We actually have a form at CAR called the Buyer Material Issues Form. I'm sad to say I don't see it used a lot. I think it needs to be used more frequently. But the key word is material, Buyer Material Issues Form. If you have the buyer complete that form, they are going to tell you what is material to them. So we created that form in an effort to put it back, an affirmative duty back on the buyer to tell us what was material to them, so that we could at least nail down a little bit of it, and we could determine whether or not we are making those disclosures. And so any material fact known to the seller, and we're going to talk about aware when we talk about the TDS in just a second, affecting the value of or desirability of the real estate. Okay, has everybody got that? So in other words, anything that might affect the value or the desirability of the property. All right. Okay, that includes, by the way, a duty to amend. And so we have an obligation, the seller has an obligation to disclose what they knew or should have known about the property, but then they also must amend that disclosure if it comes at a later time. And we're gonna see in a second when we talk about how the law has changed recently about the TDS and the application of it. Okay, so remember that you may not waive a statutory right. And so the buyer can't say, I don't need the TDS, right? It is against public policy for that to happen, okay? Since the TDS is statutory, it may not be waived. So statutory means it's a law. Again, Civil Code 1102, it is a law, and so you may not waive it. It says that in the statute. It also says that in the RPA, okay? So that includes attempting to contract around it, and I've seen people try to do that. I mean, it's interesting how that can transpose itself. Remember that the TDS belongs to the seller, and I say that because on pages 1 and 2 of the TDS are the parts for completion by the seller, not by the real estate agent. And so one of the things, it was interesting, I made a comment in a meeting, in a Zip Forms Advisory Committee meeting probably 20 years ago, and I just, because I was management at a very large brokerage in town, actually goodness, it was a lot farther than that back, longer than that ago. And I made the comment, I said, our agents are filling out the TDS for the seller. And then, of course, the seller defends the fact that they didn't disclose something because it wasn't their disclosure. The agent filled it out. And so you could always tell, because at that time, the agent, when you would pull the form up, they would check the boxes, the perfect little X's and the perfect little spaces. And so ultimately they resulted in lawsuits. Plaintiff's counsel said, "Is this your disclosure?" And the seller says no. And the plaintiff's counsel says, "Well, is this your signature here?" And the seller would say yes. And they say, "Well, why did you sign it if it wasn't your disclosure?" And the seller would say, "I was told to sign it, so I signed it." And so you can imagine how that's going to go. So a lot of these cases, they get through into depositions, and by that point, you spent some real money trying to defend this. And so it does not belong to the real estate agent. And we're going to see, I'm going to show you page 3, the most common problems I see with the completion of the transfer disclosure statement. So again, the seller completes the disclosures on pages 1 and 2 with the advice and counsel of the agent. So I'm going to tell you, I've seen enough of this in court where the agent sends the TDS off to the seller and says, "Do the best you can." I'm going to tell you that's a very poor defense. I would sit with the seller if you have to. I would get them on a Zoom call or on Google Meet or Google Meet or Microsoft Teams. But if you can't be physically with them, then at least they can have it on their screen, you can have it on your screen, and you can guide them through the process of filling it out. But the last thing that you want to do, folks, is sending this thing over to the seller and just saying, "Here, figure it out," right? Okay, so put your hands back and say, "Well, they filled it out," but you did not help them, you did not advise and counsel them. Okay, and so we have a broker in our office who went down to the seller's place of residence and sat with the seller and completed the TDS with the seller, helped the seller, with the explanation of what it was that they were looking at. And I personally have had this happen. In fact, recently, I don't usually take listings because I don't compete with our agents, but took a listing up in Lake Forest and sat down with the seller for 3.5 hours and completed every single disclosure. And the seller did all the work. I was just there to help them. So we're getting paid a lot of money to do what we do. You don't want to just throw it out there and say, "Here, do this," and then be surprised at the fact that there's litigation later and we get dragged into that. So the seller completes the disclosures on pages 1 and 2 with the advice and counsel of the agent, and then they sign at the top of page 3. Section 1 now has changed. And so I'm going to show you section 1, and I'm going to show you a really good Q&A from the California Association of Realtors about what's called the substituted disclosure. So again, note substituted disclosures. The top of page 1 is very important. We rarely see it completed properly. Section 2, rarely complete. Almost never complete. And remember that an incomplete TDS risks a lawsuit for defective disclosure. And again, it's a state real estate exam question. So hopefully you've seen this before. Paragraph number 3 again is the agent's visual inspection disclosure. The TDS is considered incomplete until the seller's agent's Avid is given to the buyer. This is a very important point. This is a very recent development in the law. The TDS is not complete until the agent's Avid. So if you're a practitioner like me and the seller's agent sends you the TDS and says, "I'll get my Avid to you as soon as possible," my advice is that you do your Avid at the time that you take the listing. Okay, and so you should be going through the property, not at the time that the physical inspector is there. Remember, their inspection is not a substitute for your obligation to do that. That's an investigation usually commissioned by the buyer. Your job is merely to do an inspection. Okay, so I have people call me all the time. Do they have an obligation to unlock doors and go off site and things like that? And what if it's a homeowners association area? Do they have to inspect the common area? Questions like that. Okay, so paragraph number 4 will be the buyer's agent's visual inspection disclosure, and then in paragraph number 5, the parties and the agent sign it after all of the above are complete, and this is another common problem that I see in the TDS, acknowledging receipt of the completed form. And so they shouldn't be signing, the seller should not be signing in paragraph number 5 if the buyer's agent hasn't completed paragraph number 4 yet, because essentially the buyer's agent is completing above the seller's signature, and I think we're going to probably have some fraud issues on that. So let's take a look at the TDS. I want to pull that up, and I've already started the process if I can find it. Here is our take us to our templates. And so I've created a template just for this. And I just want to make a comment about templates. And so when we updated the forms on June the 26th, June the 27th, I remember because I was waiting for it to happen. It didn't happen until the afternoon and I was excited to see and still saw some mistakes, but again, we'll clarify those at some point. But when they did update the forms, they updated the library. Okay, over here on the right-hand side, I look at my all forms and I look at, this is the library. Notice at the top, form libraries. Everybody can see that, okay? So form libraries. So they updated the libraries. Now, if you want to know what the updates were, I'm going to click this all button right here, and I'm going to go down to form update for 623, and I can see all of the forms that were updated in the publication in 623. Okay, so now I know what's been updated. I know there were only 4 new forms, and I know there were 67 revisions of existing forms. Most of those revisions are merely topical, minor revisions, words missing, things like that. I don't know at this point if they've fixed yet solar systems versus solar power systems, stuff like that. But those were some of the things that they did. And again, I think I just did a new forms class on this subject as well. So we are in, so again, the library will be updated. It will be the previous forms will now be the most current forms, and the new forms will be added into the library. The same is true for your template. So if you have created a template, they will update the forms in your template. So if you have a form in the template, you will now have the new version of the form in the template. They will not add new forms. Well, the good news, as I said a second ago, is that there's only 4 new forms. So you would use probably more, your contingency removal form used to be 1 form for both the buyer and the seller. Now they've bifurcated the 2 of them. Now there's a contingency removal form for the buyer and a separate one for the seller. Make sure that moving forward in a real estate transaction, if you haven't had the form signed by the client yet, then make sure you use the new form. So they're not going to update a transaction that you have in progress. That's your job, right? They are going to update the forms that are in your template. And that's one of the reasons why it is so important to have a template. And I talk about it all the time, and yet I still encounter people that are using forms from 10 years ago. So let's make sure we're using the current forms. And again, because it's protection for not only you and your broker, but also the buyer and for the seller. Okay, everybody good with me so far? So anyway, I'm in the template. I'm going to show you, I'm going to open up the transfer disclosure statement here in just a second. And I have a lot of ancillary forms in here as well. But I wanted to show you something that came across my window, as we say, and it was the quick guide. So this is the transfer disclosure statement law, the overview. And again, I'll make all this available to you. Send me an email. Don't put your email address in here because I lose everything when I close this. But who's required to provide it? And again, our meeting today is essentially a summary of all of this, including, by the way, who's exempt. Okay, so remember that you do have the June quick guide. And this is the quick guide for all of the new forms and for the updated forms. And then we also have the sales disclosure chart. And again, I've poured through all of this even again today because there's a new version for the sales disclosure chart, obviously, that came out January of this year. And it's a pretty good chart. I mean, if you look at it, here's what we got. Unfortunately, the way they've set this up is that the headings only appear at the top of the page. They don't appear later on. So when you scroll through the document, you've got to keep going back up and referring to the top of the page. So as I see here, I've got my residential 1 to 4. I've got my 1 to 4 units that are either probate or trust or bankruptcy. I've got my REO foreclosures. 5s and greater. Remember, the civil code is intended to protect the innocent buyer and seller. The theory being that anyone doing a residential 1 to 4, a single family home, a duplex, a triplex, or a fourplex, is the innocent buyer and seller. I think most of us who've been in the business for any period of time, we don't think that they're so innocent, but it's okay. That's the way the law looks at it. So it's not going to apply to 5s or graders because that's not civil code. That's going to be uniform commercial code, and then obviously land, it won't apply to land, things like that. Okay, so let's scroll down. I'm going to take us down to the part that addresses the transfer disclosure statement. Whoops, past it. There we go. Back up here. And so this is my transfer disclosure statement. So does it apply to residential 1 to 4? Absolutely, it does. Bankruptcies, no, you're not going to tell the court what to do. Foreclosures, no. And by the way, I say, does it apply? So the law merely says that they don't have to use the form. But they still must make the disclosure. And so we'll talk about exempt seller disclosures and things like that in just a second. But you see, no, all the way through here. And again, for my residential 1 to 4s, if they are exempt, just no obligation to use the actual form. They still need to disclose what they knew or should have known. And remember, you and I, as the real estate licensees, are never exempt. So even if the seller is exempt, then we need to complete our Avid, essentially page 3 of the TDS, and that form is provided for you in the Zip Forms program. Okay. So over here on the right-hand side, I've got the TDS for real property, the MHTDS, which I'm not going to get into, even though we do a lot of manufactured homes. But manufactured home TDS is significantly different from the transfer disclosure statement, so much so that we needed to create a separate form for it. So, so for personal property, manufactured or mobile homes, and I know some of you on the call today, I know that you do these, and so this is important for you. Make sure you're using the current version of the MHTDS, okay? And so we see over here on the right-hand side, my reference to Civil Code 1102, so that's going to be my sales disclosure chart. Does anybody have any questions about any of that here today? Seeing none. Okay, if you have a question, please stop me. And one of the best effects of asking a question is you slow me down a little bit. So anyway, wanted to show you that. That's my sales disclosure chart. I've shown you already the transfer disclosure statement law overview. And then we also have, this is the new law that just took effect. See if I can get down to it here. Here we go. So the new law that just took effect, and the commissioner is enforcing this. So TDS and related disclosures are set on the date of acceptance of the purchase agreement. So again, as it says in here, disclosures required by the TDS law, so Civil Code 1102, in effect on the date the parties entered into the contract, shall be the disclosure requirements that apply to that sales contract. So in other words, whatever the law was when you put your transaction together, that's the law that's going to apply. If the law changes a week later or a month later, then that law doesn't apply. It only applies to when the date was that you put the transaction together. And that's going to be fairly important in a lot of different respects. So, but again, we're going to see in a second, this doesn't just include the TDS. So any subsequent changes to the TDS law after the parties enter into the sales contract will not apply to that contract unless the statute says they do. Okay, so states otherwise. Everybody all right with that? So again, it will apply to TDS related disclosure. And by the way, that includes the NHD, which is Civil Code 1103. That includes the Melrose, the disclosure of Melrose. A lot of people aren't aware of the fact that if the property is located in the Melrose assessment district, the seller must make the disclosure that it is. And that is usually carried through. I know that I get asked a lot about natural hazard disclosures, and I'm going to tell you, you to be very careful about who you're using in your natural hazard disclosure to make sure that these items are also part of those disclosures in those natural hazard statements. Okay, so anyway, it goes through a list of all this stuff. I did want to show that to you. And then we also have our transfer disclosure statement law, a previous version of it, which had some good iterations in it. Question. Hi, McKay. Came on late. If I missed any, yeah, of course, all the best stuff happens in the first 30 minutes. So here we go. Thanks for being here. So the TDS law, and again, I'll send this to you. But again, our talk today is essentially a summary of what of this information. I'm going to break the form out in just a second for those of you that have arrived later. And so then we have an additional Q&A on TDS and the smoke detectors. And so we'll talk about that in a second. But I want to call your attention also to the fact that the Department of Real Estate takes this very seriously. And so the transfer and financing of real property, and this is RE 29. So here it is, disclosures upon transfer of residential property. This makes really good reading. You really should get familiar with it. You don't have to be an expert on this, but you do need to know, what they're talking about. Okay, and we'll come back to the exemptions here in just a second. And one of the comments I wanted to make about the TDS and smoke detectors is that smoke detectors are included in the current iteration of the transfer disclosure statement, so you don't need a separate form for that. Everybody good? So as I said a second ago, we do have exemptions, and here are the exemptions that the Department of Real Estate publishes. Sale of new homes, obviously subject to, instead of the transfer disclosure statement, the developer comes together with a subdivision report. Foreclosure sales, why? Because when a bank takes a property back, and again, this is a subject matter that I speak about a lot, but when a bank takes property back, they end up taking it back. They're taking back paper. They don't have any interest in the property itself. And in recent years, last 15 years now, since the craziness of 2007 and 2008, banks started exercising dominion and control over property. And yes, that came out of the court holding. And so when they started to do that, then they could essentially become a seller, a normal seller like everybody else. And so, but in a foreclosure sale, where they sell a property that they have taken back, they don't have an obligation to make a disclosure. Again, the agents do, the bank does if they knew or should have known. A court order transfer, you're not going to hold the court to anything. Transfers by a fiduciary, the administration of a decedent's estate. And so guardianship, conservatorship, or trust, except where the trustee is a former owner of the property. And that's a very limited interpretation of what that is, because if the trustee lived in the property, or if they had more than just received a property in trust, they could be held subject to the TDS. Again, all that exemption does is says they don't have to use the form, they still have to make the disclosure. So certainly transfers to a spouse or to a person or persons in the lineal line of consanguinity. How do you like that, McKay? I said that pretty well, didn't I? Transfers resulting from a judgment of dissolution of marriage, or from legal separation, or from a property settlement agreement incidental to such a judgment. Transfers from one co-owner to another, no TDS is required. Transfers by the state controller for unclaimed property. Transfers resulting from failure to pay taxes. And then, of course, transfers to or from any government entity, the TDS is not going to be required. Okay, and then I have a Q&A for you revised last year about this time, and that is the California's take on the exemptions to the TDS. Again, we're gonna hit some of this. I wanted to show you the TDS before it became hot at the end of June, and so this is the transfer disclosure statement. You've got to make sure you see it. A couple of changes that occurred. This property is a duplex, triplex, or fourplex. A TDS is required for all units. So that means if it's a duplex, you'll need 2 TDSs. So which one is this one for? This one is for all the units, or this one is only for these units. Again, it'll be based on knowledge and things like that. Actually, I could probably go ahead and use this instead of using the hard copy of it, just so you can see the changes that were made. So frequently when I see this document, did I show you? I think I showed you substitute disclosures. Yeah. So when I see this document, I'm looking at the top, at the header, I'm looking to see if this is completed properly. Now, in most cases where the agent created the listing agreement in the Zip Forms program, this information is automatically populated from that beginning of that agreement. They create the listing agreement, and so we have the header across the top, the recitals as we call them, and they copy across to all the forms. So this very top part should be correct, but you want to make sure that you check it for the fact that it is correct. Notice that it says the statement is a disclosure of the condition of the property in compliance with Civil Code 1102 as of this date. So people, I'll see that frequently not filled in. The date is when this is completed by the seller. So if you are sending this to the seller, you would put that date in there. If you are sitting in front of the seller would complete that date as the date they completed the TDS. So as of this date, this is what the date is for the transfer disclosure statement. Okay. All right. And again, we take out, it's not a warranty of any kind, things like that. Then we get into paragraph number or section number 1, which is coordination with other disclosures. There's a really good writing by CAR on the subject for this and what ended up happening. And so in the previous versions of the transfer disclosure statement, there was one part that was noticeably missing, and it was the part down here that says no substituted disclosures for this transfer. This was added in the previous iteration of the TDS. And so notice up at the top where it says substituted disclosures, they're required by law, including the natural hazard disclosure. So those are not going to be considered to be a substitute disclosure because they are a completely separate statute that requires those. Okay, so following disclosures and other disclosures required by law, including the NHD, et cetera, however, will be made in connection with the transfer and are intended to satisfy disclosure obligations on this form, but they are not a substitute for this form. And so the first 2 checkboxes were the part that confused a lot of different people. They thought, well, was there a physical inspection? Do I need to include it in here? No, because nothing that, in most cases, nothing that you have is going to be a substitute for the seller's obligation to disclose. And so that's why I have here the new addition, no substitute disclosures for this transfer. And so according to the learned bodies out there, that is normally the box that's probably going to be checked in the event. But one of these must be checked. And if one of the 3 is not checked, then it becomes a defective TDS. It becomes an incomplete disclosure. So just be aware that in most cases, the third one is the one that gets checked, but there are always the possibilities that the first 2 would have to get checked. One of them would have to get checked. So then I get to section number 2, which is my seller's information. And again, not a warranty. And the seller authorizes the agent to provide a copy of it to the person involved in the transaction. So following representations are made by the seller and not the representations of the agent. We just had to say that because, here we had agents completing TDSs on behalf of sellers. Okay. Now I have seen, even to this day, I have seen people go to great lengths to try to circumvent the seller filling it out. They'll send it to themselves to another email address. They'll complete it. Then they'll send it to the seller for signature. That is just not going to work. And obviously you're manipulating the program to try to find a way around it. That's not going to go well. Seller is or is not occupying the property. It seems like a simple question. Sometimes I get, well, the seller stays in the property for 3 months out of the year. Do they become subject to, having to say that they are occupying the property or that they're not occupying the property? And those are good questions for your broker, and certainly a good question that the seller should probably ask their attorney. I get down to paragraph number A. The subject property has the items checked below. So the seller would check which of these items would be involved in the transfer. I always tell the seller, if you're not going to include it in the transfer, don't check the box. But then more importantly, I get down here to the bottom of this page where I start to see the things that get missed frequently. So exhaust fans, 220-volt wiring, I rarely ever see this done. And if you are sitting with a seller, or if you are on that, that Google Meet or Microsoft Teams or Zoom or whatever, you need to be telling the seller to fill this information in. Okay, the roof, the type, the age, if you're aware roughly. But then the big one that I always end up sending them back back to the seller's agent, are there, to the best of your seller's knowledge, okay, we're going to talk about aware, any of the above that are not an operating condition, yes or no. In this box, I frequently get this TDS where this box is not checked. I need at least one check mark, either yes or no. And if it doesn't have a yes or no, I'm going to send it back to the seller's agent. And I'm going to say, hey, I am more than happy to provide this to the buyer, but you do understand that the seller did not complete the document. Do you want to give the seller an opportunity to complete the document prior to me giving it to the buyer? And so frequently I will give it to the buyer as it is and say there's another one coming, but I want to make sure, and this is always good when we catch this in the transaction, never good when we catch it after the transaction. So I'm frequently going to send that back to the seller's agent and ask them to complete it. If the seller says no, everything is working just fine, then the answer is no. And again, remember, to the best of their knowledge, right? If the answer is yes, just describe what the problem is. If you got to go to additional sheets, then you perhaps you could do it on a separate sheet of paper. I don't like emails for this purpose. Or as I'm going to show you in a minute, you do have the addendum form that you can use. In fact, let me show you that because I'm going to get timed out on this program, unfortunately. Here's my addendum form, and as you can see from the form itself, at the top of the form, one of the check boxes right here is transfer disclosure statement. So I'm going to check the box, transfer disclosure statement, but be aware that an amendment to the TDS may give the buyer the right to rescind. And so then the seller would put those items in here, or you would put them in, then have the seller sign those items. Okay, but this was intended to be an amendment, or actually an addendum to the TDS, but it could also be an amendment, right? And so remember, the difference between an addendum and an amendment is an addendum adds to things, so it could be used to add to the TDS, but an amendment changes things. Okay, all right. Okay, so that being said, I'm going to take us back. I am going to want to come back to the original here, but I want to make sure that there isn't anything else that whoops, wrong form. Okay, TDS, page 2, same kind of thing. Obviously, I should see an address up here. I should see the date up here. Are you, the seller, aware of any significant defects or malfunctions in any of the following? Yes or no? So I know it sounds like a simple question. If the answer is no, everything's fine, I don't know of any problems with any of this stuff, then they answer it no. But if there is something, they answer it yes. And so again, if your seller says to you, well, they have this thing here, should I disclose that? And I don't know, my advice is always, it can't hurt you to make a disclosure. I would recommend the disclosure. Okay, so certainly, as Pete said, if they can't sue you for what you tell them. Okay, all right. So again, explanation, describe it. If you need more, go to additional sheets if necessary. Okay, then I get down into my language. Again, this is a statutory form. So the only legislator I'm aware of that has a real estate license is Brian Jones out of Santee. And I think so. Again, the intention here is to have is to protect the consumer. Question: how do you have your clients fill out these forms? The $1 million question. So I think I'm going to take us over to the hard version, because I think the only change we really made was to the date. Yeah, it did. Okay, so to the date. So Rachel, thank you for asking the question. I'm going to take us over here to my transfer disclosure form. And so this is the original, or this is the current version. Notice the date up here at the top, 6/23. So all the things, you notice the grayed out area here. So you don't have the ability to fill this part out, right? So editable by seller number 1. Right. When I click on the field in here, can you see that? See the pop up? No. Yes, you can see editable by seller number 1. So in other words, you're not supposed to do that. Okay. Again, when you send it to the seller in your electronic signature platform, then the seller is able to complete it on their end. Now, in the alternative, if they can't figure out how to do that, and it's working a lot better than it did when we first came out with it, but you can always send the form itself to the seller and ask them to print it and complete it. Okay. Not you complete it and send it to them for signature. That's not going to be appropriate. Again, we want to make sure it's the seller's disclosure. Okay. So that's what all these grayed out areas are here. All right. Paragraph number C, almost always see this one messed up. You've got your seller who says there's nothing wrong with my place, and so then they complete no all the way down through the column. I don't know how you could possibly have a no to everything here. Okay, and then let's talk about a couple of them really quick. When I'm teaching this at the university, it's a 3-hour class. We only get 2 hours, and we've got to talk about 4 forms. So substances, we added the word mold to this about 20 years ago, so that you really almost can't say no. But if the seller's not aware, because the standard here is only knew or should have known, were they aware of something? And if they aren't aware of it, then the answer is no. Very simple. Features of the property shared in common with adjoining landowners. Frequently a wall, a fence, a driveway. Who has responsibility for that? Nobody seems to know. And so it's probably going to be a feature shared in common. So I don't know, that's probably going to be a yes, unless the seller has information to the contrary. Encroachments, easements. So, again, I'm not going to break it too deep here. An encroachment is something that trespasses upon your property. Could be a tree overhanging, could be roots under the ground. It could be, I had a case in La Jolla where the water from the adjoining property was coming under the fence, of course, and flooding the subject property. That would be an encroachment. An easement is someone else who has the right to use the property of another. So for example, your utility companies, things like that, almost all of them have easements. So I'm not sure the legislative body intended that, but when I fill out a TDS, the answer is yes, because it's got easements on it. But most sellers say there's nothing wrong with my place. It has nothing to do with it. So room additions, structural modifications, other repairs without necessary permits. And part of what came out of the Easton case is, where it was something that might be readily visible to the real estate agent that might not be visible to the buyer. I sold a property in 92104. I remember well, it was 30 years ago, and I remember there was a second story on this property, and I remember walking up the stairs to the second floor, and I always tell everybody I'm 6'6", right? And so I'm rubbing my head, and actually I'm not 6'6", I'm much shorter than that, and I was rubbing my head. I had to know that could not have been done right? So not done with the necessary permits. There were other things about that particular house. I'm not going to tell you the address only because, but I remember it. Great transaction, owned by an SDG&E worker. The power to the second floor was an extension cord coming out of the bus fuses from the backyard. Again, never forget that transaction. That was a great one. So one cord powering the entire second floor. How about room additions, et cetera, that are not in compliance with building code? Sometimes they can be done better than code, right? They can be in compliance, but and not have the permits, right? But is there anything not in compliance with the building code? And that's going to be a decision for the seller, certainly not you, because you don't have an expertise in code enforcement. Fill, compacted or otherwise. Fill versus cut, right? Cut is when they cut the ground to level it. Fill is where they bring other dirt in to level it. Any settling, flooding, drainage, or grading problems, major damage to the property from any of the 3 big ones, of course, right? Fire, earthquake, flood, landslide came out of the Easton case. Okay, all right. Zoning violations, non-conforming uses, right? So non-conforming use would be a use that was maybe legal at some point, but then the code changed around it, and there's no requirement necessarily for them to go back and bring it up to that. So that would essentially become a non-conforming use. Violation of setback, you can usually tell, the seller can tell that the property is really close to the street, things like that. Neighborhood noise problems, I just never have, in my house, I'm oceanfront. I have helicopters coming by, at all hours of the day and night. I got the train coming by. I got all that kind of stuff. I've lived there long enough that maybe I'm forgetting that to make those disclosures. But pretty much all properties are going to have some kind of noise. Every morning around 5 o'clock, I've got the surfers outside scraping down their surfboards, things like that. So did you make those disclosures? CC&Rs. or other deed restrictions or obligations. I think it does. The question is not yet homeowners association. Question is CC&Rs. I think all properties have restrictions on their use. My property is 800 square feet. You got to go outside, change your mind. I'm literally a single story. Can I build a 16-story high rise there? I'm going to tell you there's going to be a deed restriction that says I can't do that. Okay. All right. Now we get to the homeowners association, which has authority over the subject property. Yes or no? Any common area? Yes or no? Notices of abatement or citations against the property. The seller would know if they had a notice of abatement, which means, clean this up. If you don't clean it up, the fire department usually issues this. If you don't clean this up, we'll come out and clean it up for you. Then we're going to put it on your tax bill. And if you don't pay that, they can take your property back for not paying your taxes. Everybody okay with that? So that's my notices of abatement or citations. Any lawsuit by or against the seller. So seller suing, seller being sued, the property on property, threatening to affect the title to the property, including lawsuits or damages for deficiencies in common areas. So be aware of that. So, and again, if an answer is yes, then you put in the answer down here, the seller puts in an explanation of what that might be. So I frequently have people who answer C1 that says mold, and so they put down here, mold is everywhere, right? It's part of the life process. And so, what they really were contemplating would be some kind of mold damage to the property. But again, you don't know what mold is. And I frequently ask the people that ask me, what's the difference between mold and mildew? So if you don't know the answer to that, I wouldn't be saying that it has mold. I would never use that word, okay? Then at the bottom, and this is something that we talked about in our previous material, seller certifies essentially health and safety code operable smoke detectors. Okay, and so that takes care of my smoke detector statement of compliance. And then I have my water heater anchored or braced. So my water heater statement of compliance. So the seller is saying that as of closing, they will be in compliance if they are not currently in compliance. Everybody good? Seller certifies that the information herein is true and correct. And the seller signs it. So that's the seller's signature on the bottom of page 2. Notice that the seller signs it. Why we have them initial it as well, I don't know, but we've got the buyer and the seller's initials on the bottom of page 2. Then we get into page number 3. And in page number 3, we start off. Wow, we fixed it. Okay, so now seller's signature does fit on the bottom of page 2. So we were having a real hard time cramming it all in there. The seller's signature was normally appearing at the top of page 3 for the longest time. So remember what I said earlier? The agent's visual, the seller's agent's visual inspection disclosure. The TDS is not complete until the agent provides their disclosure to the buyer. Okay, so again, to be completed only if the seller is represented by an agent in the transaction. And so based on the undersigned, based on the above inquiry of the seller as to the condition of the property, and based on a reasonably competent, diligent visual inspection of the accessible areas of the property in conjunction with that inquiry, states the following. Okay, so any real estate attorney that you speak with, this just kind of rolls off the tongue, right? Because we talk about this all the time. Reasonably competent, diligent visual inspection of the accessible areas of the property. Okay, so no obligation. You've all had pest inspections done, and they all almost consistently come out with inaccessible areas, so they're going to recommend a bag. You don't have an obligation to go digging through stuff or going to heroic efforts to that part of the property, but you must, in the immortal words of the district manager for the Department of Real Estate, you're going to have to defend the fact that you actually visited the property. Okay, so in most cases, this language here that talks about the Avid form was added probably about 15 years ago. But prior to that line wasn't there. There are only the 2 lines, and it would say agent notes no items. And again, if you've got a property that you've done an inspection on, you can't come up with anything, I'll go out there with you, and I guarantee you that you'll come up with pages of stuff. So we did have in the form for the longest time, again, this is a statutory form, agent notes the following items. And so one of the bad things that we had people do for many, many years was was they would put in recommend physical inspection by licensed contractor. And I know some of you on this call today are laughing because you remember that that's what people did. So then you go to court, of course, and the judge says, you know, why did you shirk your 2079 duty to inspect the property? And in the immortal words of the district manager of the Department of Real Estate, it's the only thing we ask you to do. I think we ask you to do a lot of other things, but it's an interesting comment that you have an obligation. So I think that you go out to any property, I don't think there's enough room here for you to fill in the stuff. You sure don't want to divert your obligation to someone else. Okay, so that's not going to be an effective strategy. So I recommend the agent's visual inspection disclosure form. It's fairly thorough, and we're going to get to that form here today as well. I'm trying to pace myself, but obviously we spent the most time on the TDS. So the buyer's agent either checks this box and says I'm doing the Avid or not. Either going to do it, and again, check with your broker. I suspect your broker is probably going to require it. The broker representing the seller, the company name goes here, the agent's name goes here, and again, if it's yours, you sign it. Don't be turning it over to somebody else to have them sign it with your name on it. Okay. All right. Then I get into paragraph number 4. Only if there's another agent, so other than dual agency, right? Then the buyer's agent would complete this. And here's that same language: based on a reasonably competent, diligent visual inspection of accessible areas of the property, states the following. Same kind of thing the seller's agent. I think the seller's agent is probably going to be more aware of things that are wrong with the property. But again, the buyer's agent needs to be filling in this as well. Remember what I said earlier, TDS is not complete till the seller's agent's disclosure goes over to the buyer. Then we have the buyer's agent's disclosure. Same kind of things apparent in there. Agent, broker obtaining the offer, very simply said, company name, licensee's name. All right. And then I get down to paragraph number 5. And so almost without fail, every time I get a TDS from a seller's agent, this part's already complete. The seller's already signed it. The agent's already signed it. Why? Because they don't want to have to come back to it again. The problem is when they have that done, when they sign it before the buyer's agent fills in their part, they're saying that we've got a copy of the above. And so the above didn't include the agent's, the buyer's agent's inspection. So in our office, at least, we make them sign it again. Because once our buyer's agent fills in their part of the form, now we have the seller's agent, we have the seller who has signed something, the agent had them sign something that said that they've received a copy of our stuff. They haven't received it. So now we have them sign it again. But it was part of the problem occurred in the signing software where again, they're not real estate people. They don't understand that part of it, but they would have the seller and the seller's agent's fields applied in there so that the seller would just sign it, right? They would just keep on going. And that was prior to having paragraph number 4, which was the buyer's agent's information being put in there. Is everybody good with that? Everybody understand what I'm saying? Really, really important. If you get a TDS where the seller's already signed it and the agent's already signed it, make them sign it again. Okay, because otherwise, what does it say? It says right here that you have acknowledged a receipt of a copy of the statement, which means a copy of everything above. And you, as the buyer's agent, filling out above a signature, you could have some maybe perhaps fraud issues. Okay, all right. Look down here at the bottom. One of my favorite parts of the TDS. So 1102, they don't even say California Civil Code. 1102.3 of the Civil Code provides a buyer with a right to rescind. Now, rescind is a very powerful word at law, and we're going to talk more about that this afternoon at 2 o'clock. But I do have a couple of pieces of material in here for you. Rescind says put the parties back in the position that they were in prior to contract. Can you imagine how powerful that is? So, what ends up happening invariably is I put a transaction together between the buyer and the seller, and then a week later, I get the TDS from the seller's agent. And so, the buyer now has 3 to 5 days, depending on the circumstance. If it was personally delivered to them, then 3 days. If it was delivered by mail, 5 days. Things like that. It's all included in the stuff that I'm going to send you. But they have the power to rescind the contract. What normally happens is they use that to renegotiate the contract, which is not good, right? Because that's not really, the seller has to make a good faith effort to fill this out. So my advice to all of you sellers agents out there, when you take a listing on a property, property, you need to get all these statutory disclosures completed at the time of the listing, so that when the offer comes in, you send all of these disclosures over with the counter offer, if any. Okay, so prior to the buyer committing to the contract. So it says right here, for at least 3 days after delivery of the disclosure, if delivery occurs after the signing of an offer to purchase. So if you get this over to the buyer before they commit to the contract, the law says essentially that you knew what you were buying because you already have the disclosures. And again, we did this in our Lake Forest transaction, 3.5 hours of time with the seller. And when the offer came in, we sent all the disclosures over. The buyer's agent said, wow, I've never seen that happen. I said, well, you should be seeing it in every transaction. They got all the statutory disclosures. In fact, we also had all the contractual disclosures. We had a death on the property. We had unpermitted additions to the property, and all those disclosures were made to the buyer before they signed the counter offer. Everybody understand what I'm saying? So because they got them before they did that, that meant that they didn't have that right to rescind. Okay, so, and again, if you wish to rescind, you've got to act within the time period, 3 days after delivery, if personally, 5 days if by mail. And again, the real estate advisor is qualified to advise on real estate. If you want legal advice, kick it over to the attorney. You need to have the attorney look at it. A lot of times, folks, they're going to put you in harm's way because they're going to say, well, I really don't want to pay an attorney to tell me what's the answer to that. And so I love answering that. I don't know what to tell you. It's legal advice, and I don't give legal advice. Okay, so I don't know what to tell you. I will tell them to read the agreement, but if they, I have the ability as a real estate licensee to explain the contracts with people. But when we get into statutory disclosures, I'm going to think that that's going to be something they need to talk to counsel about. Is everybody good with that? That's a pretty good cover of the TDS. Okay, all right. Seeing no questions, let's go back to, so that was our TDS. One of my favorite documents. Again, as I said earlier, almost never completed properly. Okay, so let's talk about the seller property questionnaire. So I want you to think of this in terms of 4. So I've got my TDS. Then I've got my SPQ, then I've got my SPQA, then I've got my Avid. And I think really the Avid arguably could be right after the TDS, right? Because it's required to be completed. The TDS is incomplete until we get one, or until that section is completed, right? But I've got the 4, and I'm going to tell you I'm going to have the 4 in every transaction that I do. All right. Now, and that's true in San Diego County. Obviously, if you're not in San Diego County, then the SPQA would not be an appropriate form to have. Although I think it's got a lot of really good stuff in it. But why did we create the SPQ? And the answer is because the TDS didn't quite cut it, right? And I think if you've done this long enough, you know that there are a lot of questions, even statutory questions, that are not asked in the TDS. The SPQ came along with an attempt to unpeel that onion. We wanted to jog the seller's memory about things that weren't necessarily included in the TDS, and the SPQ accomplishes that. Plus, it makes additional disclosures. So a couple of things. It is a contractual obligation. I just want you to know that. It's in paragraph number 11, right, of the RPA. Let's see here. I can show you. Here's the purchase agreement. And I'm going to take us down. Sorry, I hope I don't make anybody seasick here. But my statutory and other disclosures right here, paragraph number 11, one of my favorite paragraphs. And it says in here, it is going to be a contractual disclosure, not a statutory disclosure. So they made it a requirement of the contract, and we argued about it for a long time as to whether or not we wanted to make it a checkbox or not. And we chose to make it just part of the contract. So let's see, down here is my language. Seller has completed and answered all questions and signed the seller's information section, and the seller's agent, if any, has completed and signed the seller's agent's section number 3, or if applicable, my Avid, correct? Okay, section 5, acknowledgement received a copy of the TDS shall be signed after all the previous sections, if applicable, have been completed. Again, it may not be applicable. It could be that there was no seller's agent, could be there was no buyer's agent. We're gonna have some problems in that we're providing forms for a seller who's not represented, okay? But again, nothing here stated herein relieves the buyer's agent agent, if any, from the obligation to conduct a reasonably competent diligent visual inspection. In other words, we want the seller's agent's inspection, but the buyer's agent is also going to have to do that. And so so here's my complete an SPQ by answering all the questions and delivering them to a copy to the buyer. And if exempt, then complete the exempt seller disclosure if exempt. And remember again now that the decision as to whether or not the seller is exempt doesn't apply to you anyway, but the decision as to whether or not they are exempt is a legal decision. So you definitely, if somebody thinks they're exempt, then you need to definitely have them talk to counsel, and you definitely need to talk to your broker. I had a transaction recently where they were convinced that they were TDS exempt, asked for it. I did not feel that they were exempt, so I continued to ask for it. I have it in my file that I continue to ask for it. They refused to provide it, and again, they were being told that by their broker, which is, you know, they should listen to their broker. But again, to this day, I don't think that that transaction, and so obviously I've got a file on that I'm going to be kicking up to the Department of Real Estate. So let me see, was there something else in here? I think that's most all of it. So that's where we're going to be talking. That was the language that I was looking for, that it is a contractual obligation. It is not a statutory obligation. It is in the contract. Remember that the parties may not waive a statutory right, but this would be a contractual right. And if the seller refuses to provide one, and even after counseling by the agent, they continue to do so, again, I'm going to keep asking for it. I'm going to have multiple letters in the file that says, you know, we need to have that SPQ. And so for the seller's agent to come back with that, I think is going to create a problem for the seller's agent. So it is intended to decode those items that the TDS misses. It's also the standard of practice in California. And frankly, it came out of the San Diego Association of Realtors Risk Management Committee, where we had a form called the SAD, the Seller's Additional Disclosures Form. And CAR liked it so much, they said, we need to create a statewide form. And I think they did a great job on it. So it is the standard of practice in California, okay? Are you, the seller, aware of? And so we're going to take a look at that form here in just a second. It mirrors the language in the TDS. Let's take a look at the SPQ. So SPQ is kind of fun. We won't have to spend quite as much time on it as we did with the TDS. The TDS is a much different deal. There is I forgot to mention the exempt seller disclosure. Here is the exempt seller disclosure. So this is where the sellers who are exempt from completing a TDS, or for a seller who does not provide an SPQ, there are some additional disclosures that need to be made that are not included on the TDS. So again, Civil Code 1710, death of an occupant of the property, on the property, things like that. So this is my exempt seller disclosure. I wanted to make sure that you saw that. Let's take a look at my seller property questionnaire. Again, this has been redone just recently. Make sure you're using the current version. June of this year, form was redone. It is not a substitute. I want to highlight that, not a substitute for the TDS, used by the seller to provide additional information where the TDS is required. If the seller is exempt, then the seller should complete the ESD, the exempt seller disclosure. Okay, so and again, you know, you tell the seller you need to be reading all this stuff. This information up here will auto-populate. We've added the language that came with the TDS that we saw a minute ago, the new language that says it's a duplex, triplex, or fourplex, et cetera, et cetera. So what are my disclosure limitations? And so again, they are the disclosures of the seller. They are not of the agent, if any. So again, not a warranty, et cetera, et cetera. And anything else in there that's hot? No. Okay. Note to the seller the purpose, known material or significant items affecting the value or desirability of the property, or in the immortal words of the Department of Real Estate, of the real estate, and help eliminate misunderstandings. Again, as I said earlier, unpeeling the onion so that we can get more to the stuff that is not being obviously asked in the TDS. And again, answer based on actual knowledge. If you knew, you knew. If you didn't know, you didn't know. Okay. Note to the buyer, same kind of stuff. This is important to you. You need to say something about it or do further investigation. And so then they go into great lengths to discuss the seller's awareness of things. Again, if you aren't aware, then the answer is no. If you are aware, then the answer is yes. If you are confused, then you need to talk to somebody about that. The real estate agent is there to help guide you through the process, but they are not there to answer it for you. So documents, are you aware of any documents? Again, if you've got any kind of reports or anything like that that would be helpful to the buyer. Of course, we always believe that you should, the seller, are you the seller aware, should be giving all of that to the buyer anyway. In that situation I was telling you about in Lake Forest, the buyer got all the disclosures, a monster document, and the buyer said, well, I think I pretty much, know everything I need to know about the property. It was supposed to be a 30-day escrow. I'll close this in 13 days. And so they did. They closed it in 13 days. And so they said, because we pretty much know everything. Now, remember, again, the disclosures are not intended to be a substitute of the buyer's obligation to investigate the property. We're going to see that when we hit the Avid in just a minute. Okay. All right. Or a couple of minutes. Okay. So statutorily, so again, the SPQ covers some of the things that the TDS did not cover. So when I get to paragraph number 6, here's some of the, so again, Civil Code 1710, the death of an occupant of the property on the property, and I call you out with of the property on the property, upon the property. And so, it's like if you think of the Heaven's Gate catastrophe in Rancho Santa Fe many years ago, the buyer of that property, after, of course, 40 people off themselves on the property, the buyer of the property leveled the building and put up a whole new building. Do they still have an obligation to disclose the 40 deaths on the property? I think they do. But it doesn't say in bedroom number 3. It says on the property, upon the property. And so again, that disclosure is going to be important, and it could have been in a corner of the property, outside someplace. The question is merely death on the property. Again, that's Civil Code 1710. We'll go deeper into that in this afternoon's class. So methamphetamine contamination, the seller would know it's a recorded document. Release of a controlled substance on or beneath the property, whether the property is an industrial zone. These are the statutory disclosures that were not taken up by the TDS. Okay. Interestingly enough, in other states where I'm a broker and I teach, the state prepares the disclosures for you. And I just think that's a fascinating concept. It's just part of what your taxes do, that kind of thing. Is there a nuisance? Are you near a former federal or state ordinance? There's no I in ordinance. Ordinance is stuff that goes boom. An ordinance is a rule or regulation that you're expected to follow. So if you're in Coronado or you're Tierra Santa, you're near previous locations for these things. And so the answer would probably be yes. And then finally, whether the property is a condominium or located in a planned unit development. Anytime you see common area, that's what's going to trigger that. Okay, so insurance claims affecting the property within the last 5 years, matters affecting title, plumbing, material facts not disclosed in here, repairs and alterations. And again, I want to spend a lot of time on the Avid when we get to the Avid. But repairs and alterations, did you do anything? And part of the fun that we're going to have here today is when I show you the SPQA, which is San Diego's response to CAR creating a statewide disclosure form. Now San Diego created a local disclosure called the Seller Property Questionnaire Addendum, and it will only talk about those items that are not called out by the SPQ. So because a lot of the stuff was fine, but the attorneys on our risk management committee said, you know what, we've got some other stuff that is particular San Diego County. Obviously, those are things that you are going to be held to the standard of care, standard of practice in San Diego County. I had an attorney call me when they had a broker they were representing, and they said the broker didn't provide the SPQA form, and before I had a chance to say anything, they said, I know, standard of care, standard of practice. All I could do was shake my head. I don't know what to tell you. You should have used it. So, but anyway, so here we are, repairs and alterations, if any, whether the property was built before 78, so already you're triggering that lead-based paint, and then whether or not, more importantly, recently, the EPA's lead-based paint renovation rule, whether that's going to apply, structural systems and appliances, disaster relief, water-related and mold issues. Whether you know what mold is or not, it asks you questions about standing water, things like that. Pets, animals and pests, I like going through this form with clients, so hopefully you share my enthusiasm. Landscaping, pools and spas, common interest. Question, Rachel, what is the SPQA? It is the San Diego form. Yes, so you have the TDS, the SPQ, which is the seller property questionnaire, and then you have the SPQA, which is the seller property questionnaire addendum. And we're going to cover that one next. So thank you for asking. It's a very, very important form. Okay. You'll find it in the San Diego library. So San Diego Risk Management Library, if you go up here on the right-hand side and you see California Association of Realtors, everybody sees that. I go down in here, I click on San Diego Risk Management Forms. And it may be someplace else in your queue here. I've organized everything for the ones I most frequently use. And so I'll see right here my seller property questionnaire addendum. If you don't have the San Diego Risk Management forms, then you need to get a hold of membership. Thank you, Rachel. Get a hold of membership 858-715-8040 and have them guide you through the process. You don't have to be a member of San Diego to have access to these forms. But if you are a member of San Diego, then they're free. I think San Diego's charging $69 a year. So if you're a member of another association and you don't want to have, you want to pay for these separately, I think it's less expensive just be a member, and you can even be a secondary member and still have access to these forms. So kind of an important thing. All right. So condominiums, common interest, developments and other subdivisions, title ownership, liens and legal claims, neighbors, neighborhoods, things like that. Again, as I said earlier, here's my trains. The very first day after I purchased my property in Del Mar, that train was amazing. Rachel, when was this implemented? The SPQA came out shortly after the SPQ did. So the SPQ has been probably 15 years now. Anyway, that train going by, I tell you, thought the world was coming to an end, and I'm on the bluff, so I thought everything was going to go down the bluff. But again, do I remember to disclose that to the buyer? And again, all this is just bringing it up to front of mind so that I can say something about that. Any past or present disputes or issues with a neighbor, governmental intervention on your property. Anybody have anything going on there? And then other, including cannabis cultivation or growth, things like that. And then if checked, additional comments. And so now the seller is going to sign it saying, I'm being truthful. I've filled this out in good faith. And again, the restatement that it's independent from any duty of disclosure that a real estate licensee may have. And then the buyer gets it and the buyer signs it. So I'm going to tell you, it is the standard of care in California. So you want to make sure you have this form completed by the seller. Again, if you're the seller's agent, I would have the seller fill this out at the time of the listing. That way you can send it over to the buyer with the counter offer. Any questions on any of this? Okay, seeing none, I'm going to go back to my PowerPoint really quick. Here we go. Let's talk about that SPQA, the Seller Property Questionnaire Addendum. Again, a San Diego form. And again, it is not included in the purchase agreement. So what we normally do in our offer is that we go here to the offer form, again, our RPA form, and we're gonna go down here to paragraph number 4. Whoops. Got it going a little too fast there. Sorry about that. Paragraph number 4, and we usually put it in for other addenda. We usually check this box and then put SDAR forms. Here, let me complete that for you. SDAR forms, APA, LAD, SPQA. So because we do want it to be part of the contract. And so we put that in there, and then that way we're going to provide the APA and the LAD, but the seller's agent, we're going to ask them to have the seller complete the SPQA. Okay, so simple enough. That's how we handle it. Back to my PowerPoint. So again, SDR forms, SPQA, and again, it is an addendum. It could be a contractual obligation, which is what I just showed you how to make it one just a second ago. And it is intended to decode those items that the TDS and the SPQ miss. Okay, and wait till you see when I show you the form. It's pretty effective form. It's not as extensive because there are a lot of things that are taken care of in the TDS and the SPQ that don't need to be handled with the SPQA. It is the standard of practice in San Diego County. So so your transaction needs to have this. So let's take a look at that SPQA. So I'm going to take us back over to my document here, my SPQ. We talked about the SPQ already. Let's talk about the SPQA. And then once again, this is the created by the Greater San Diego Association of Realtors, intended for use primarily in the San Diego County area. And it is not covered by the CAR User Protection Agreement, which, by the way, the User Protection Agreement is that they will write a letter on your behalf at the appellate level of a lawsuit over any of the pre-printed language. So I find that rarely ever happens. And part of the reason behind that is it's just so very well written. And again, the conversation on the SPQ is with the attorneys, with the committee, with practitioners, and then obviously DRE doesn't require it unless it's a contract item, but I think it's fairly well written. So the SPQA comes along intended. Right here, it says it must not be used without the SPQ. Okay, you have to have it with the SPQ, and then the headings, as I say, which is very well done here. Look at this, the SPQ, paragraph number 5, things like that. I want to take you down to the bottom of this page really quick just to show you the copyright date. Look at this, January of this year. So when this group puts these things together, there's a lot of time that is spent on that. All right, and so paragraphs below are numbered to assist you in comparing them to the SPQ. So as I said earlier, I put my TDS down, and next to that I put my SPQ, and next to that I put my SPQA. I want them all in order because they all talk to each other, and they're always all part of my transactions in San Diego County. We do transactions all over the state of California. When we're doing things in San Francisco, we don't use the SPQA, but obviously it's a good memory jog for a seller when we take a listing in that area. Okay, so you should consult with a qualified California real estate attorney. We've coined the term the QCREA, and the broker cannot answer questions on the legal sufficiency of any of the answers. So paragraph number, for the SPQ, paragraph number 5, the seller awareness. We really didn't have anything to say about that because we thought it was pretty well covered in the SPQ. Paragraph number 6, same thing. Paragraph number 7, we've added to attach a copy, if available, of any documents such as a receipt, an invoice, or report. And remember, again, we also have the seller statement on repairs available in the San Diego library. So when I go back up here, I see right here, seller statement on repairs. I like that form. That one was also redone in January of this year. And essentially it's where the seller says, here's the work that I did, here's the work somebody else did, here's the receipts, here's the agreements, here's the bill, that kind of thing. And so certainly a very good form. Structural systems and appliances, we get a paragraph number 8. And so we did have a lot to say about the roof that we felt wasn't covered sufficiently in the SPQ form. Are you aware of any hardwood floors? These are questions that are not asked in the SPQ. All right. And so if yes to answers 1 and 2, use section O at the end of the addendum to specify what rooms. Okay. Again, my copyright date, and then I noticed that this one is 6 pages long, and again, written so that it's legible, so that we understand it. Leased or financed items and systems, something that's not even covered in the TDS, but is covered in the SPQ, and obviously, we want to make sure that we drill into that. So again, are you the seller aware of the following, right? And if yes to any of those items, so leased or financed items, so hero loans, those kinds of things, then you definitely want to see. Hopefully you'll get it. We just did a transaction where the seller's agent claimed not to have any copy of any receipts from the solar power system, and then ultimately our buyer hired a company that went out and was able to actually sleuth sleuth through it and figure out who it was, who the agreement was with, all that kind of stuff. So listen, that's good money for the buyer to pay. You certainly don't want to take responsibility for that. Type of system, type of item, type of system, propane tanks, obviously, water softeners, alarms, solar panels, those kinds of things. And then is there a UCC filing? So in a lot of cases where we have solar power systems on the property, I had a broker tell me that it's going to be included in the prelim. It's not included in the prelim. It's not going to be included in the prelim because it's not necessarily a matter of that record. It's a UCC filing. For some strange reason, it always seems to appear, right before closing. And again, according to Eric Ginder, one of the attorneys who I'm not sure if he's still on the committee or not, but he made the comment. He said my average lawsuit's about $58,000, and that's because that's about what's left on the seller's obligation to pay for that solar power system. I had an agreement fairly recently where our buyer happens to be our agent, happens to be a practicing litigator, an attorney, buying a property. Seller's agent counters with solar power system does not convey, or actually they said solar system does not convey. And so because the seller believed that they were going to be able to take it, their company had told them they could take it to the property that they were literally purchasing across the street, only to find out in the middle of the transaction, and the buyer didn't want it. And only in the middle of the transaction that the company could move it, but it would take a year to do it. The buyer says, no, I'm buying the house now. And so it was very expensive. The seller ended up having to pay off that $58,000. So be really careful about those items in the property. Again, not just the solar power. You've got water softeners, alarms, propane tanks, things like that. Are they leased or are they owned? Paragraph number 9, disaster relief, a couple more questions in there. Paragraph 10 and 11, nothing to talk about, right? They did a pretty good job in the SPQ. Boundaries, access, and properties used by others. I've often said that good fences make good neighbors, but they don't make good property boundaries. I've had enough of these where the seller's agent said, when asked, how far does the property go? And they say, well, it goes back to that fence. Fences are almost never put together by surveyors. They're almost never on the property line. I've had them go beyond the property. I've had them be, short. I had one where there were several properties before we even got to the fence. And so be careful about statements that you might make about that. And then landscaping, pool and spa, obviously only one question in there. Common interest condominiums and developments, parking, storage, modifications, things like that. So title ownership and legal claims. Again, anybody else that's got an interest in this property, is there any litigation out there? I sold a property in Cardiff Cove, 2919 Cape Sebastian Place. I don't think that unit is actually there anymore, but I saw some really high lawyer bills, and sure enough, the seller wasn't even aware the complex was in litigation. So those are kinds of things that we get to looking at. Neighborhood itself, anything affecting views, governmental, other. I'm just going through this really quick because I do want to get to my Avid. Multifamily property, and then any additional information. Again, make sure, folks, that the seller has checked all of the boxes. I get these back frequently where the seller, if they didn't understand something or didn't have the answer to it, they just wouldn't check it. Okay, that while it's not a statutory requirement, we need to find out whether or not it's they skipped it because they didn't know, or skipped it because they didn't want to answer it. And so I've had it happen. I had a lawsuit where the seller was sued by the buyer because they had not checked a box. The seller subsequently amended it, created a whole new form, and checked the box. And the buyer still sued 3 years later. The seller's in court. The buyer saying that they thought that the seller was trying to hide something, but obviously disclosure was made prior to the closing, well before the closing. Again, so we want to make sure that those boxes all get completed. Prior transaction disclosures. So if you're with a larger company that knows that it's got their footprint on a lot of transactions, a lot of properties in the San Diego area, are you aware aware of any disclosures reports. So in my Lake Forest example, the seller who had been the buyer 3 years earlier still had copies of their TDS and their seller property questionnaire and all their disclosures. They provided all those disclosures to the buyer. And so, yeah, if you've got copies of them, I know some of the larger companies out here, the larger brokerages, actually retain those records. I recommend that you retain your disclosures forever, well, forever. I'm throwing them out from 1984 right now, but you know, those disclosures will set you free. If you touch on that property again at some point, you probably should have been downloading those disclosures. Okay. And then finally, down here at the bottom, seller acknowledges the seller has read and completed the addendum and certifies that the information is correct. Then we get the buyer to initial, and then we have the great big, this is excellent. I'm surprised CAR hasn't done anything equivalent to this, but SDAR has it in their addendum. Buyer's legal duty to exercise reasonable care. And as we launch into the Avid here in just a second, you're going to see that this will save you a lot of trouble. The attorneys will be really good. The defense counsel will be really good at pulling this up and asking the buyer, is that your signature? And the answer is yes. Well, okay, so what part of that didn't you understand? And did you ask your agent to explain it to you, right? So this is a great defense mechanism for certainly for the seller, but as well as for the agent. I had a lawsuit where the buyer stated in court that they thought that the seller's obligation to disclose and the agent's obligation to inspect satisfied their obligation to do their investigation of the property, and so it's a whole separate thing. So and they lost. So it was interesting, and the plaintiff buyer was an attorney, and so interesting outcome to that case. Went really well, but I'm going to show you one of the things here in a second when we get into the Avid. I'm going to show you what it was in the Avid that was in big 10-inch letters up on the board, where defense counsel asked the buyer, you know, did you see this? So let's take a look. We're going to talk about, let's talk about the agent's visual inspection disclosure, the Avid, one of my favorite forms. And again, one that I frequently find not to be completed properly. So the Avid, remember that the TDS is considered incomplete until the seller's agent provides their Avid to the buyer. And the Avid is going to have 3 sections to it. It's going to have, the first section is going to be the disclosures and the indemnification. That's on page 1. Page 2 is about the interior of the property. Page 3 is about the exterior of the property. Remember that your job is to disclose, not diagnose. And so I say this in every class that I do, and yet invariably I get an Avid back and the Avid will say, you know, it just needs a little grease, or, you know, it's sticking because of this. Those are statements I would probably not be making in my Avid. So let's take a look at the Avid. I want to go through that. It looks like we might even get done here a little bit early. It's going to be close, but let's take a look at my Avid. I want to go in here. I want to look at my agent's visual inspection disclosure. And again, that is my Avid form. And notice this is not 1102. Remember, 1102 applies to the seller. Civil Code 1102 is to the seller. This is your obligation. And again, your obligation is independent of the seller's obligation. All right. So if the seller is exempt, then you're still going to do this, right? So when the TDS is required, or when the seller is exempt from completing a TDS, you are still covered by Civil Code 2079. You need to be aware of that. You need to make that disclosure. So this form was last revised in 12/21. And again, this is out of my template, folks. So I know it's the current form. Okay, so across the top, I have my recitals again. I have my language. This property is a duplex, triplex, or fourplex. Avid is required for all unit. This is for all the units or only a particular unit. In other words, you have an obligation to make, you know, if they're all the same, then they're all the same. I doubt it. I would be making it for each of the units, but okay. So the inspection is performed by, what is the real estate broker's firm name that is doing the inspection? So this form can be used for the buyer's agent. It can also be used for the seller's agent, but never on the same form unless they're dual agent, right? So, so who is doing the inspection? So California law requires, with limited exceptions, page 1, there's nothing for you to do except make sure it's filled out properly, all right? So again, we're going to conduct a reasonably competent, diligent visual inspection of reasonably and normally accessible areas of certain properties, right? Offer for sale, and then make the disclosures on them, okay? Duty applies for residential real properties that are 1 to 4 dwelling units, right? Civil Code 1102, 2079, our obligation, and manufactured homes, otherwise known as mobile homes. Duty applies to a standalone detached dwelling or to an attached dwelling, such as a condominium. Also applies to a lease. This is important. A lease with an option to purchase, a ground lease, or a real property sales contract of one of those properties. If you are getting involved in a option to purchase, this needs to be done at the outset of that option, not done later on. The risk for you and I is that you might be triggering the buyer's belief that they have a right to rescind the contract. Now, whether they have that right or not is going to be a subject for matter for the attorneys, but I'm going to tell you, I don't want to create the doubt. So again, if you are the seller's agent, have this form completed at the time that you take the listing. If you are the buyer's agent, I would take it at the time of contract. I would go in and do this reasonably competent, diligent visual inspection. The same thing as holds true with the transfer disclosure statement. If something happens later on during the course of the transaction that changes your observation, then you need to make a note of that change as well. Okay. All right. Again, if you have the seller change the TDS, then you want to have them initial where they made the change, so it's really obvious to the buyer what those changes were. And the same thing is going to hold true for your Avid. Okay. All right. So California law does not require the agent, areas that are not reasonably and normally accessible, areas off-site of the property, including common areas, right? So common areas of planned unit developments and all that are outside of our purview. And please do not be pulling permits for the buyer or for the seller. There are companies out there that will do that for you. You have no obligation by law to inspect any of those things. Okay. All right. Okay, so agents inspection limitations. So this goes through again, how many times we got to say reasonably competent, diligent visual inspection, et cetera, et cetera. Roof in the attic. Agent, I love this. I've had agents do this, that climb onto the roof. You know what the liability for that is, especially that you're not a roof inspector for one thing. It's a whole separate field. I would have the buyer employ a roof inspector that would go out and do that. So you miss something, you bought it, you slip and fall, whose insurance covers that, that kind of thing. Interior, we're not going to move furniture around. Pictures of wall hangings, they're not going to look up into chimneys. Can you believe that? Or into cabinets, or open locked doors. And I had this call from an attorney the other day. Do they have an obligation to unlock the door? And I would say no. If you can't get into the property, then if you can't get into the place, you don't have an obligation to do that. Excuse me. Exterior, you're not going to inspect beneath the house, climb up or down a hillside, move. I love this stuff. You have no obligation to move anything. Right. So I had a transaction that we did in Del Mar, where we represented the buyer. The seller had a basement. It was one of those houses on that cliff. So there's like 4 levels to this house, and so each level had its own bedroom kind of thing. And down at the very bottom there was a room that was filled with boxes. Seller was moving, I get it, but filled with boxes, and the agents went into the property, didn't move anything, didn't have an obligation to. They could smell that there was this musty odor down there. They noted the odor, but they didn't move anything around. And then I get a call from the attorney a couple months later, where the buyer is suing the seller because when the seller did remove all the boxes, there were the stains on the wall that turned out to be stachybotrys, toxic mold, stuff like that. But then it got even worse. The seller, it turned out in the course of inquiry that the seller had received a check from their insurance company to repair the damage, and didn't do it. They just kept the money. And so needless to say, they didn't need me in the case. So I was like, okay, well, I'd love to testify, but they didn't need me. It was one of our agents had done done their reasonably competent, diligent visual inspection, accessible areas of the property, no obligation to move anything, and they didn't. They smelled something, they noted it, but that was about it. So just be aware of that. Appliances and systems, size of property and improvements. We don't measure square footage. Please don't do that. Your MLS requires that you put the estimated square footage of the property. I would always take the tax records information. If there's a discrepancy between the two, then you might want to have somebody explain that. But it's not uncommon. It happens that improvements were done, county was aware of it, they never updated the system, that kind of thing. So use the SFLS form, the square footage and lot size advisory form for that purpose. Here's what the MLS says, here's what the tax record says, here's what the seller says. I would be using those forms. Environmental hazards, we don't know what mold is, right? Difference between mold and mildew, don't know. Asbestos, now I have a graduate certificate in hazardous materials management. I got a pretty good idea how this stuff works, but again, I'm going to refer that to an authority on that. I'm not going to go out and test for lead-based paint or radon or anything like that. So off-property conditions, again, not obligated to pull permits, et cetera, and then analysis of the agent's disclosures. Agent will not provide an analysis of any of that or the cost to determine possible repair. Like I said earlier, please don't say things like it just needs a new handle or there's a part missing or something. That's none of your business, okay? So this is the paragraph I was talking to you about earlier. This is the paragraph in 10-inch letters up on the board in front of the jury. What this means to you, the buyer, an agent's inspection not intended to take the place of any other type of inspection, nor is it a substitute for full and complete disclosure by the seller. We're going to separate ourselves from everybody, right? So, seller's duty is to disclose what they knew or should have known. Buyer's duty is to investigate the property. Agent's duty, conduct a reasonably competent, diligent inspection, not investigation, inspection of the property. So those are three completely separate requirements. All right. So regardless of what the agent's inspection reveals or what the disclosure the sellers make, the buyer still has a duty to exercise reasonable care to protect him or herself. I love that language. And so again, this is a great defense. If you're not using the Avid, you need to be talking to your broker about that. Okay. So diligent attention and observation of the buyer. And then in bold print, buyer should review any disclosures obtained by the seller, obtain advice about and inspections of the property from the appropriate professional. So you call the inspector who did the inspection for you to get don't use the real estate agent, don't want to be conflicting or even opining on anything that other people are writing because you're not that expert on that. And so, for you to get into an analysis of the physical inspector's report or even to deny it or condemn it, is outside of your field of expertise. So review any. So again, number three, review any findings of those professionals with the person. We'll review them, but we're not going to opine on them. So if the buyer fails to do so, big words, buyer's acting against the advice of the broker. And by the way, for some of you, you know by now that we do have acting against the advice of broker form. So right here where you see where it says CAR sample letters, I'm going to click that up in here for you. Here's my letter, acting against the broker's advice on the buyer side. So, I downloaded that. Here it is, notice to agent or broker. So obviously you don't print this page, but it tells you here's how you fill out the form. I told you to have a physical inspection on the property. You decided to have a contingent free offer because you thought that's what it took to get the property. I've told you not to do that. And so this is my acting against the advice of the broker letter. Okay, written for you by CAR. It's actually a pretty good commentary on the SDAR confirming letter. I like the confirming letter better. SDAR's version is better, but only because they had to make a much more general statement here. But Jackie Oliver, one of our attorneys, wrote a really good confirming letter, and it even includes instructions on how to fill it out. So if you go back over here. Okay, they don't have it. They took it out of the library because CAR created a conflicting form. So, but it is available on the website, or send me an email and I'll send it to you. So back to my Avid, we're just having way too much fun, aren't we? So back to my Avid. That's a monster paragraph. So again, not a lot for you to do, but you do need to read it and make sure you don't make comments or assertions that are inconsistent with it. Then I get down to page 2. Now I'm talking about the interior of the property. This all needs to be filled out. I had one of our brokers send us, who was present. They had themselves in there. And I said, who else was there? They said, well, this person, this one. Okay, you need to put them in there too, right? Because they become witnesses, right? That you did this. You put in weather conditions, cloudy, sunny, rainy. You put in sunny because every day in San Diego is sunny. And of course, plaintiff's counsel is going to go back to that date, time, and see it was raining cats and dogs, right? I don't know. Can we say cats and dogs in California? I don't remember. Anyway, so the date and the time are 2 separate fields. Make sure that's being completed. Here's my restatement again of a reasonably competent and diligent visual inspection. How many times we got to say that? And so I'm going to put in my entry. Now, here's what I want you to know. If you look in the room and you don't see anything, then you're not aware of, you don't visualize something, then what do? You put nothing noted, okay, or something to that effect. Check with your broker and do what your broker tells you to do. If it doesn't have a living room, right, it'll always have a living room before it has a family room, then I'll put NA, okay, if it doesn't even have the room. But if I go through the property and I want to be able to, in the immortal words of Veronica Kilpatrick, and she's the district manager for the Department of Real Estate. When she says something, I'm listening, right? I write notes constantly. And so, she says, you need to be able to defend the fact that you actually visited the property. And so this is pretty important. And I had a conversation with an agent yesterday about this. Notice this field up here that says include photos, attached photo, detached photo. So as you are doing your Avid at the property, take pictures. You can attach your pictures to the Avid. You've got essentially unlimited bandwidth, right? You can attach your pictures to the Avid. This is the place you do that. That photos only shows up on this form. So I'm going to recommend to you that you take pictures, right? What? A picture's worth 1,000 words. Okay, so you'll put in, stain noted on wall, right? That kind of thing. And then here's a photo. All right. I mean, it's going to really be hard for people to deny the fact that you talked about it, and and notice I didn't say water stain. So I had a case where the agent put in to the transaction that water stain noted in northeast corner of bedroom number 4. And of course, after closing, the buyer went up into the attic to repair the water stain, and it turned out it was paint cans. And so it became hazardous materials. Big lawsuit, tons of money. This is about 30 years ago. It was about 250 grand, which back then was a lot of money. I know most of you are driving cars today that cost more than that. But at the end of the day, attach photos, take pictures, disclose, don't diagnose. But again, if the room doesn't exist, NA. If you looked in the room and you saw something, you didn't see anything, jumping out at you, then nothing noted. If you went to the dining room and you saw stains noted on carpet, I think you're probably going to be okay, right? Stains noted, I can spell. Stains noted on carpet, I think you're going to be okay. Pet stains, no. Cat urine, no. Paint, no. Just say stain. Okay, and when do we get to the driveway? I always love talking about the driveway. So everybody follow me so far. If I don't see anything in the room, nothing noted. Now I'm going to challenge you. You got to look around, okay? But if you don't see anything, I had another case where the agent noted, minor settling cracks in a room in the house that 2 weeks after closing, the room broke off from the house. It had been built on partial cut and then fill the rest so that it would fit the footprint of the slab, and the slab broke off. And the evidence was the crack in the the walls near the windows, right? Because it always cracks near the windows. Windows are always the first thing they put in. So cracks, they should have just said cracks noted, but instead they said minor settling cracks. I see that a lot with driveways, people putting in, minor settling cracks. And by the way, I've bought property with cracked slabs before. And so I have it checked by a geo, geo company to do that, geologic survey, come out, they take a look at it. I bought one where the tenant literally had taken all the carpet up in the house because they like the natural feel of the concrete. I'm like, really, the natural feel? What you really were doing were you were exposing the crack that ran the length of the unit. And so I bought it. I said, I had a guy come out, take a look at it, a company come out out of Solana Beach, come out, take a look at it. And they said, nah, it's normal. It's probably been there since they built the place in 1960. And so, but the tenant was using it to scare people off. And so cracked slabs are not necessarily a bad thing, but again, the buyer needs to have that investigated. And so I ended up buying the property, sold it for huge profit. So, what did they do? They went in and they put an epoxy fill and fixed it, certified it. Everything was good. Everything was fine. Remember, carpet cures a lot of evil. So a lot of times carpet will hide things. I have had people that had cracks in their kitchens, for example, replace the tile only to find out that it cracks again right away because tile is not very forgiving. Carpet is. So I'm not trying to tell you how to prevent, how to hide something, but that's what people do. So, but on the other hand, as an agent, I had a case once where the agent pulled the carpet up in the corner of one of the rooms and said, slab looks fine to me. And then unfortunately, of course, there was a 3-inch separation on the slab in the other part of the house but that slab looks fine to me. They have no obligation to pull that carpet up. Should not have done that, right? No obligation to move furniture, no obligation to do any of those things. And so you're all here today. Hopefully you won't be having that problem. But again, don't go to heroic efforts. You're not that person. All right. So stains noted on carpet, chips in countertop. And notice I'm not going and saying, where on the countertop, things like that. I'll note those items in my disclosure. Okay. Other room, if any, hall excluding common areas. Delete that so that I have to use this again. Bedrooms. So we've gotten away from master apparently across the country now. We're just the primary room or whatever. But number 1, number 2, number 3, name the rooms. And again, if you've got to use an additional page to talk about the others, this gives you room for three bedrooms, 3 bathrooms. And again, you could either amend it addend it, use it as an addendum someplace for the other rooms if there are any, but you need to know what those rooms are and name them 1, 2, 3, 4. So maybe the primary room is bedroom number 1, whatever. Other room, if any, we give you a space for that. Then we get into paragraph, the 3rd page. And again, now we're going outside the property. So any other things to talk about, see addendum for additional rooms or structures, it's got a barn or, things like that. Garage parking, I frequently see, settling cracks noted in driveway. I have never seen a slab that was poured that didn't have a crack in it. They all have cracks. One way or another, they're going to have a crack. So your job, again, just disclose the existence of the crack, something that you saw, not diagnose what it is. Again, no more minor or settling or normal or easy to fix or anything like that. But more commonly, I see that in garage and parking area, cracks noted on driveway, easy, right? Okay. Exterior of the building, front, sides, back, anything. Other observe, you're not an investigator. You're an inspector. You just go and see what you see and then bring it up. I had an attorney hire me recently, had me go through the house. There were some questions about the agent's Avid. And so I went through the house, did my Avid, they're going to use it for purposes of litigation. And you know what? The house looked fine to me, but I'm not going to say that on the form. I'm not going to say looks good, nothing wrong. It's never going to say that, but I will note the cracks. I will note things as I observe them. And obviously I'll be able to defend the fact that I actually went to the property. So here's the big gotcha. So I get down here to the bottom of page 3 of the Avid. This disclosure is based, again, geez, how many times are we going to hear these words, right? And look, firm who performed the inspection. So it should be the same firm as the one back on page 1, right? But the key down here is who performed the inspection. It's the signature of the associate licensee or broker who performed it. And so this is what the DRE goes after, is that the agent goes out and does their Avid, takes it back to the office, and then the team lead signs off on it. Well, the team lead never went to the property, and the form very clearly, listen, they read our forms, right? You need to read your forms. So I read enough of these administrative hearings that I'm going to tell you something. They read our forms. Why aren't we reading our forms? So you need to read the form, and the form says who performed the inspection. So if you hand it over to somebody else, even in a transaction that up in Lake Forest, Joe went around, one of our brokers went around and did the Avid for the property. I didn't do the Avid, so I did not sign it. His name was on it. He signed it. I did not do it. I'm not signing it. Okay. Now I could do my own as well, but again, we're both under the same broker and we're both brokers. So, Joe did a great job. And this is the gotcha. I got a couple questions popping up in here. Hey, McKay. Oh my gosh. 105,000 square foot home. Now that I need to get paid to do that. Oh man. Wow. Can you imagine 105,000 square foot? Now I was in the Klein estate in Rancho Santa Fe, which was roughly 40,000 square feet. That was an impressive property. I mean, wow. But yeah, I believe it. We've got some big properties out there. So, does that mean you don't have to be quite as diligent? I would be very diligent. The bigger the property, probably the more lawyers, right? So I would definitely be doing a very thorough inspection of the property. So this is the big hot button right here on this page. This is the big hot button that they're looking at right now. They want to know it's the signature of the person that actually did the inspection. Okay. All right. And notice it actually, the form has changed a bit since prior to 21. In 21, it changed. Not all defects are observable by how many times we got to say things to try to protect our agents, right? So, why would you not use this form? I don't get it. Okay. But the inspection does not include testing of any system or component. We're not home inspectors. We're clearly not contractors. Stop opining on construction. It looks pretty well built to me. Probably the best built house in the whole neighborhood. You are going to cook for that. Okay. No, don't do that. Buyers should obtain advice about inspections of the property from other appropriate professionals. So, I always tell people use San Diego's got a great form, the buyer's election of inspections form. And I don't know, it's even, there it is. Yeah. Buyer's election of inspections form. I'll pull it up for you here because I love this form, right? CAR created a form that conflicts with it. I'm surprised they even still let us have ours in there. But look at this thing. This is a monster. This one is 7 pages long versus the one that CAR created that's 1 page long. It goes through all of these different types of inspections that a buyer could do. Now, I'm not criticizing CAR. What they write is excellent for the state standard on things, and I'm certainly not more gifted than they are. But I like the San Diego form. And I would make sure that form was included in my information to the buyer, because I want the buyer to know that there are all these other different types of inspections that you can do, not just the physical inspection. That's the part the buyer is thinking, oh, I just have to have a physical inspection. Well, there's a manometer, there's the electrical inspection, there's the roof inspection, there's all those different kinds of inspections that are called out on those forms. And so I'm thinking that, you might want to have the buyer at least let them know that those other types of inspections exist, because they're going to come back later on and say, well, I had no idea. Well, now you just signed off on a 7-page form that had all those other inspections associated with them. Okay. So if the buyer fails again, and I don't use fails in my college classes because I think you neglected to pass rather than you failed. Buyers acting against the advice of the broker. Okay. Makes sense. The buyer says, I acknowledge, I've read it, I understand it, I've received a copy of it, right? So obviously if they get a copy of it within 24 hours, that's the DRE requirement, within 24 hours, they don't say anything for 3 years, then why didn't you say something? Right. Okay. And then down here, we acknowledge received a copy of the disclosure, and in this case, the seller only initials it, and the initials are not required. It says it right there, but it can be used as evidence that the initialing party received the form. You want the seller to have a copy of your inspection of the property, okay? And so then I've got, again, my firm representing the seller. Again, this should not have been signed at the time of the listing. So in other words, the seller is, I'm sorry, the seller will sign it after the buyer has signed it. Okay, so that's what I'm looking for here, after the buyer, whether it's the seller's agent or the buyer's agent. I wouldn't sign it until after, because you never want to sign below a blank, right? And so for the lawyers on this call, you know what I'm talking about. Never sign below a blank, right? Because what happens? They go and fill stuff up above your signature, and so that's, I don't know. DRE throws that word fraud around there, and I think they're right, but that's going to be their call. So the agent representing the seller would sign it after the above is completed, and then the agent representing the buyer would sign it after that. Any questions on the Avid? I love the Avid. I just think it's one of the least understood forms. I think it's simple when you read it, but it's we got to read it, okay? And I think it contains a lot of protection for us. So just really quickly, in a couple of minutes we have left, statutory disclosure is one that's required by law. It contains rescission rights. Failure to make the statutory disclosure gives the offended party a right to reset the contract, right? In other words, put the parties back in the position they were in prior to contract. Okay, it's huge repercussions in a real estate transaction. Again, it has to be a completed disclosure. All right, contractual disclosure, it's one that's required by contract. And again, determined by the relationship between the parties. They may have cancellation rights. They may have the ability to exit the transaction. You are more likely to get involved in a lawsuit over a cancellation right than you are on a rescission right. Okay, because the rescission right's statutory. All right, so I want to thank you for joining us. I got you done. Oh God, I can't believe it. Anyway, I want to thank you for joining us. I've really enjoyed this one. I spent a day and a half rewriting the entire thing from what I did the last time, because there was a lot of really cool stuff to talk about. But I want to thank you for being here today. I know you have other things to do, and 2 hours is a long time listening to me. But again, I want to thank you all for being here for our presentation today. So all of the forms that I talked about, remember, I will send you those forms. If you send me an email, just say, would you please send me your file, and I will send it. It'll be in a Dropbox link, so that you can open it up and do whatever you want to with it. I find in my experience, a lot of times people ask me for it and then never open it, but okay, whatever. But thank you, Hannah. Thank you very much for that. So thank you all for being here today. If you want any of my webinars, I load them all up onto the YouTube website. So we have a new YouTube website. Get your QR code reader ready. Here's the QR code. I learned how to do, McKay, you'll be impressed. I learned how to do this about a month ago, and so now I'm using that. And then or you can go to @ Burke Real Estate Consultants Inc., and that'll take you to the YouTube website. There's a bit.ly link. Case is important, so bit.ly/real-estate-ed. And thank you to Christine Fallon, who is our liaison at the education department in San Diego, for teaching me that it was an important thing. So anyway, please remember to like and subscribe. I'd really appreciate it. Only because if you subscribe, it just lets you know when I've uploaded a new video, okay? And I replace these videos. I mean, I redo them again and again. And so if you have any other subjects that you want to talk about, let's let education know. education@sdar.com. You can always send an email to me. I had an attorney send me an email and say, can you do a class on agency? Which of course for me is a fascinating subject, and I do trial work on it, but I probably talk about stuff that you wouldn't believe about agency. So let us know, or let them know. I don't work for SDAR. I have a newsletter, comes out once a week, goes out Friday night. It has the links right in it, so that you just click on the link and then it takes you directly to the signing up for the class, rather than going to other websites that say, it's sold out and all that kind of stuff. I'm going to get you in there. I want to make sure that you're there. Scott, thank you so much, Scott. Very kind of you. Cool stuff. Thank you. Great. Thank you, Scott. If there are any other questions or comments, that I do want to thank you for being here. I've run a couple of minutes over. I will be back at 2:00 to do the disclosures, statutory versus contractual. I'm digging into those pretty big. I'm going to show you all the required disclosures. We only covered 4 here. There's a bunch. So, but when you got that laundry list, you're good to go. Okay. So thank you all for being here. I very much appreciate the value of your time. And as we say from my hometown of Del Mar, I look forward to seeing you around the track. Take care for now. Bye-bye, everybody.